Starting back at page 37, proponents called two witnesses. David Blankenhorn, founder and president of the Institute of American Values, testified on marriage, fatherhood, and family structure. Plaintiffs objected to Blankenhorn's qualification as an expert, and for the reasons stated hereafter, Blankenhorn lacks the qualifications to offer opinion testimony and in any event failed to provide cogent testimony in support of proponents' factual assertions. Kenneth P. Miller, a professor of government at Claremont McKenna College, testified as an expert in American and California politics. Plaintiffs objected that Miller lacked sufficient expertise specific to gays and lesbians. Miller's testimony sought to rebut only a limited aspect of plaintiffs' equal protection claim relating to political power. David Blankenhorn. Proponents call David Blankenhorn as an expert on marriage, fatherhood, and family structure. Blankenhorn received a BA in Social Studies from Harvard College and MA in Comparative Social History from the University of Warwick in England. And after Blankenhorn completed his education, he served as a community organizer in low-income communities where he developed an interest in community and family institutions after seeing the weakened state of those institutions firsthand, as he stated, especially how children were living without their fathers. This experience led Blankenhorn in 1987 to found the Institute for American Values, which he described as a nonpartisan think tank that focuses primarily on issues of marriage, family, and child well-being. The Institute commissions research and releases reports on issues relating to fatherhood, marriage, family structure, and child well-being. The Institute also produces an annual report on the state of marriage in America. Blankenhorn has published 2 books on the subject of marriage, fatherhood, and family structure: Fatherless America, Confronting Our Most Urgent Social Problems, and The Future of Marriage. Blankenhorn has edited 4 books about family structure and marriage and has co-edited or co-authored several publications about marriage. Plaintiffs challenged Blankenhorn's qualifications as an expert because none of his relevant publications have been subjected to a traditional peer review process. He has no degrees in sociology, psychology, or anthropology, despite the importance of those fields to the subject of marriage, fatherhood, and family structure. And his study of the effects of same-sex marriage involved reading articles and having conversations with people and trying to be an informed person about it, to quote him. Plaintiffs argue that Blankenhorn's conclusions are not based on objective data or discernible methodology, and that Blankenhorn's conclusions are instead based on his interpretation of selective quotations from articles and reports. The court permitted Blankenhorn to testify but reserved the question of the appropriate weight to give to Blankenhorn's opinion. The court now determines that Blankenhorn's testimony constitutes inadmissible opinion testimony that should be given essentially no weight. Federal Rules of Evidence 702 provides that a witness may be qualified as an expert by knowledge, skill, experience, training, or education. The testimony may only be admitted if it is based on sufficient facts or data and is the product of reliable principles and methods. Expert testimony must be both relevant and reliable, with a basis in the knowledge and experience of the relevant discipline. While proponents correctly assert that formal training in the relevant disciplines and peer-reviewed publications are not dispositive of expertise, education is nevertheless important to ensure that an expert, whether basing his testimony upon professional studies or personal experience, employs in the courtroom the same level of intellectual rigor that characterizes the practice of an expert in the relevant field. Formal training shows that a proposed expert adheres to the intellectual rigor that characterizes the field, while peer-reviewed publications demonstrate an acceptance by the field that the work of the proposed expert displays at least the minimal criteria of intellectual rigor required in that field. The methodologies on which expert testimony may be based are not limited to what is generally accepted, but nothing in either Daubert or the Federal Rules of Evidence requires a district court to admit opinion evidence that is connected to existing data only by ipse dixit of the expert. The party preferring the evidence must explain the expert's methodology and demonstrate in some objectively verifiable way that the expert has both chosen a reliable method and followed it faithfully. Several factors are relevant to an expert's reliability. 1. Whether a method can be or has been tested. 2. Whether the method has been subject to peer review and publication. And 3. The known or potential rate of error. 4. The existence or maintenance of standards controlling the method's operation. 5. A degree of acceptance of the method within a relevant community. 6. Whether the expert is proposing to testify about matters growing naturally and directly out of research that have been conducted independent of the litigation. 7. Whether the expert has unjustifiably extrapolated from an accepted premise to an unfounded conclusion. 8. Whether the expert has adequately accounted for obvious alternative explanations. 9. Whether the expert employs in the courtroom the same level of intellectual rigor that characterizes the practice of the expert in the relevant field. And 10. Whether the field of expertise claimed by the expert is known to reach reliable results for the type of opinion that the expert would give. Blankenhorn offered opinions on the definition of marriage, the ideal family structure, and the potential consequences of state recognition of marriage for same-sex couples. None of Blankenhorn's opinions is reliable. Blankenhorn's first opinion is that marriage is a socially approved sexual relationship between a man and a woman. According to Blankenhorn, the primary purpose of marriage is to regulate filiation. Blankenhorn testified that the alternative and contradictory definition of marriage is that marriage is fundamentally a private adult commitment. He described this definition as focused on the tender feelings the spouses have for one another. Blankenhorn agrees that this affective dimension of marriage exists, but asserts that marriage developed independently of affection. Blankenhorn thus sets up a dichotomy for the definition of marriage. Either marriage is defined as a socially approved sexual relationship between a man and a woman for the purpose of bearing and raising children biologically related to both spouses, or marriage is a private relationship between two consenting adults. Blankenhorn did not address the definition of marriage proposed by the plaintiff's expert Cott, which subsumes Blankenhorn's dichotomy. Cott testified that marriage is a couple's choice to live with each other, to remain committed to one another, to form a household based on their feelings for one another, and their agreement to join in the economic partnership and support one another in terms of their material needs of life. There is nothing in Cott's definition that limits marriage to the affective dimension as defined by Blankenhorn, and yet Cott's definition does not emphasize the biological relationship linking dependence to both spouses. Blankenhorn relied on the quotations of others to define marriage and provided no explanation for the meaning of the passages he cited or their sources. Blankenhorn's mere recitation of text in evidence does not assist the court in understanding the evidence, because reading as much as hearing is within the ability and experience of the trier of fact. Blankenhorn testified that his research has led him to conclude that there are three universal rules that govern marriage. 1. The rule of opposites, the man-woman rule. 2. The rule of two. And 3. The rule of sex. Blankenhorn explained that there are no or almost no exceptions to the rule of opposites, despite some instances of ritualized same-sex relationships in some cultures. Blankenhorn explained that despite the widespread practice of polygamy across many cultures, the rule of two is rarely violated because even within a polygamous marriage, each marriage is separate. Question: is it your view that man who has married one wife and then another wife and then another wife and then another wife and then another wife and now has 5 wives, that they're all his wives at the same time, the marriage is consistent with your rule of two? Answer: I concur with Bronislaw Malinowski and others who say that that is consistent with the rule of two of marriage. Finally, Blankenhorn could only hypothesize instances in which the rule of sex would be violated, including where he's in prison for life and he's married and he's not in a system in which any conjugal visitation is allowed. Blankenhorn's interest in studying on the subjects of marriage, fatherhood, and family structure are evident from the record, but nothing in the record, other than the bold assurance of Blankenhorn himself, suggests that Blankenhorn's investigation into marriage has been conducted to the same level of intellectual rigor characterizing the practice of anthropologists, sociologists, or psychologists. Blankenhorn gave no explanation of the methodology that led to his definition of marriage other than his review of others' work. The court concludes that Blankenhorn's proposed definition of marriage is connected to existing data only by the ipsit dixit of Blankenhorn and accordingly rejects it. Blankenhorn's second opinion is that a body of evidence supports the conclusion that children raised by their married biological parents do better on average than children raised in other environments. The evidence Blankenhorn relied on to support his conclusion compares children raised by married biological parents with children raised by single parents, unmarried mothers, step-families, and cohabiting adults. Blankenhorn's conclusion that married biological parents provide a better family form than married non-biological families is not supported by the evidence on which he relied, because the evidence does not and does not claim to compare biological to non-biological parents. Blankenhorn did not in his testimony consider any study comparing children raised by their married biological parents to children raised by their married adoptive parents. Blankenhorn did not testify about a study comparing children raised by their married biological parents to children raised by their married parents who conceived them using an egg or sperm donor. The studies Blankenhorn relied on compare various family structures and do not emphasize biology. The studies may well support a conclusion that parents' marital status may affect child's outcome. The studies do not, however, support a conclusion that the biological connection between the parent and his or her child is a significant variable for child outcomes. The court concludes there is simply too great an analytical gap between the data and the opinion proffered. Blankenhorn's reliance on biology is unsupported by the evidence, and the court therefore rejects his conclusion that a biological link between parents and children influences children's outcomes. Blankenhorn's third opinion is that recognizing same-sex marriage will lead to the deinstitutionalization of marriage. Blankenhorn described the deinstitutionalization as being a process through which previously stable patterns and rules forming an institution like marriage slowly erode or change. Blankenhorn identified several manifestations of deinstitutionalization out of wedlock childbearing, rising divorce rates, the rise of non-marital cohabitation, increasing use of assisted reproductive technologies, and marriage for same-sex couples. To the extent Blankenhorn believes that same-sex marriage is both a cause and a symptom of deinstitutionalization, his opinion is tautological. Moreover, no credible evidence supports Blankenhorn's conclusion that same-sex marriage could lead to the other manifestations of deinstitutionalization. Blankenhorn relied on sociologist Andrew Cherlin and socialist Norval Glenn to support his opinion that same-sex marriage may speed the deinstitutionalization of marriage. Neither of these sources supports Blankenhorn's conclusion that same-sex marriage will further deinstitutionalize marriage, as neither source claims same-sex marriage is a cause of divorce or single parenthood. Nevertheless, Blankenhorn testified that the further deinstitutionalization of marriage caused by the legalization of same-sex marriage would likely manifest itself in all of the consequences already discussed. Blankenhorn's book, The Future of Marriage, lists numerous consequences of permitting same-sex couples to marry, some of which are the manifestation of deinstitutionalization listed above. Blankenhorn explained that the list of consequences arose from a group thought experiment in which an idea was written down if someone suggested it. Blankenhorn's group thought experiment began with the untested assumption that gay marriage, like almost any major social change, would be likely to generate a diverse range of consequences. The group failed to consider that recognizing the marriage of same-sex couples might lead only to minimal, if any, social consequence. During the trial, Blankenhorn was presented with a study that posed an empirical question of whether permitting marriage or civil unions of same sex would lead to manifestations. Blankenhorn described as indicative of deinstitutionalization. After reviewing and analyzing available evidence, the study concludes that laws permitting same-sex marriage or civil unions have no adverse effect on marriage, divorce, or abortion rates, the percent of children born out of wedlock, or the percent of households with children under 18 headed by men. Blankenhorn had not seen the study before trial and thus was unfamiliar with its methods or conclusions. Nevertheless, Blankenhorn dismissed the study and its results, reasoning that its authors think that the conclusion is so self-evident that anybody who has an opposing point of view is not a rational person. Blankenhorn's concern that same-sex marriage poses a threat to the institution of marriage is further undermined by his testimony that same-sex marriage and opposite-sex marriage operate almost identically. During cross-examination, Blankenhorn was shown a report produced by his institute in 2000 explaining the 6 dimensions of marriage: 1, legal contract; 2, financial partnership; 3, sacred promise; 4, sexual union; 5, personal bond; 6, family-making bond. Blankenhorn agreed that same-sex marriages and opposite-sex marriages would be identical across these 6 dimensions. When referring to the 6th dimension, family-making bond, Blankenhorn agreed that same-sex couples could raise children. Blankenhorn gave absolutely no explanation why manifestations of the deinstitutionalization of marriage would be exacerbated and not, for example, ameliorated by the presence of marriage for same-sex couples. His opinion lacks reliability, as there is simply too great an analytical gap between the data and the opinion Blankenhorn preferred. Blankenhorn was unwilling to answer many questions directly on cross-examination and was defensive in his answers. Moreover, much of his testimony contradicted his opinions. Blankenhorn testified on cross-examinations that studies show children of adoptive parents do as well as or better than children of biological parents. Blankenhorn agreed that children raised by same-sex couples would benefit if their parents were permitted to marry. Blankenhorn also testified, he wrote and agrees with the statement, "I believe that today the principles of equal human dignity must apply to gay and lesbian persons." In that sense, insofar as we are a nation founded on this principle, we would be more American on the day we permitted same-sex marriage than we were the day before. Blankenhorn stated he opposes marriage for same-sex couples because it will weaken the institution of marriage, despite his recognition that at least 13 positive consequences would flow from state recognition of marriage for same-sex couples, including 1. By increasing the number of married couples who might be interested in adoption and foster care. Same-sex marriage might well lead to fewer children growing up in state institutions and more children growing up in loving, adoptive, and foster families. And 2, same-sex marriage would signify greater social acceptance. Same-sex marriage would signify greater social acceptance of homosexual love and the worth and the validity of same-sex intimate relationships. Blankenhorn's opinions are not supported by reliable evidence or methodology, and Blankenhorn failed to consider evidence contrary to his view in presenting his testimony. The court therefore finds the opinions of Blankenhorn to be unreliable and entitled to essentially no weight. Kenneth P. Miller. Proponents call Kenneth P. Miller, professor of government at Claremont McKenna College, as an expert in American and California politics. Plaintiffs conducted voir dire to examine whether Miller had sufficient expertise to testify authoritatively on the subject of political power for gays and lesbians. Plaintiffs objected to Miller's qualifications as an expert in the area of discrimination against gays and lesbians and gay and lesbian political power, but did not object to his qualification as an expert on initiatives. Miller received a PhD from the University of California at Berkeley in 2002 in political science and is a professor of government at Claremont McKenna College. Plaintiffs contend that Miller lacks sufficient expertise to offer an opinion on the relative political power of gay men and lesbians. Having considered Miller's background, expertise, and testimony, the court concludes, while Miller has significant experience in politics generally, he is not sufficiently familiar with gay and lesbian politics specifically to offer opinions on gay and lesbian political power. Miller testified that factors determining a group's political power include money, access to lawmakers, the size and cohesion of a group, the ability to attract allies and form coalitions, and the ability to persuade. Miller explained why, in his opinion, these factors favor a conclusion that gays and lesbians have political power. Miller described religious and political and corporate support for gay and lesbian rights. Miller pointed to a failed initiative in California relating to whether public school teachers should be fired for publicly supporting homosexuality and whether HIV-positive individuals should be quarantined or reported as examples of political successes for gays and lesbians. Miller testified that political powerlessness is the ability to attract the attention of lawmakers. Correction. Miller testified that the political powerlessness is the inability to attract the attention of lawmakers. Using that test, Miller concluded that gays and lesbians have political power both nationally and in California. Plaintiffs cross-examined Miller about his knowledge of the relevant scholarship and data underlying his opinion. Miller admitted that proponents' counsel provided him with most of the materials considered in his expert report. Miller stated he did not know at the time of his deposition the status of anti-discrimination provisions to protect gays and lesbians at the state or local level. Could only identify Don't Ask, Don't Tell and the Federal Defense of Marriage Act as examples of official discrimination against gays and lesbians, and that he has read no or few books or articles by George Chauncey, Miriam Smith, Shane Phelan, Ellen Riggle, Barry Tadlock, William Eskridge, Mark Blasius, Gervasi Vade, Andrew Sullivan, or John D'Amelio. Miller admitted he had not investigated the scope of private employment discrimination against gays and lesbians and had no reason to dispute the data on discrimination presented in the Employment Non-Discrimination Act 2009 hearings. Miller did not know whether gay and lesbians had more or less political power than African Americans, either in California or nationally, because he had never researched the question. Plaintiffs questioned Miller on his earlier scholarship, criticizing the California initiative process because initiatives eschew, compromise, and foster polarization, undermine the authority and flexibility of representative government, and violate norms of openness, accountability, competence, and fairness. In 2001, Miller wrote that he was especially concerned that initiative, constitutional amendments, undermine representative democracy. Plaintiffs questioned Miller on the data showing 84% of those who attended church weekly voted yes on Proposition 8, 54% of those who attended church occasionally voted no on Proposition 8, and 83% of those who never attended church voted no on Proposition 8. Plaintiffs also asked about polling data showing 56% of those with a union member in the household voted yes on Proposition 8. Miller said he had no reason to doubt the accuracy of the polling data. Miller did not explain how the data in PX 2853 are consistent with his conclusion that many religious groups and labor unions are allies of gays and lesbians. Miller testified that he did not investigate the extent of anti-gay harassment at workplaces or in schools. Miller stated he had not investigated the ways in which anti-gay stereotypes may have influenced Proposition 8 voters. Miller agreed that a principle of political science holds that it is undesirable for a religious majority to impose its religious views on a minority. Miller explained on redirect that he had reviewed most of the materials listed in his expert report and that he had tried to review all of them. Miller testified he believes initiatives relating to marriage for same-sex couples arise as a check on the courts and do not therefore implicate a fear of the majority imposing its will on the minority. Miller explained that prohibiting same-sex couples from marriage wasn't necessarily invidious discrimination against gays and lesbians. The credibility of Miller's opinions relating to gays and lesbian political power is undermined by his admissions that he, 1, has not focused on lesbian and gay issues in his research, 2, has not read many of the sources that would be relevant in forming an opinion regarding the political powers of gays and lesbians, 3, has no basis to compare the political power of gays and lesbians to the power of other groups, including African Americans and women, 4, could not confirm that he personally identified the vast majority of the sources that he cited in his expert report. Furthermore, Miller undermined the credibility of his opinions by conceding that gays and lesbians currently face discrimination and that current discrimination is relevant to a group's